Hello everyone, my name once again is David Oni. Welcome to another segment of intellectual brainstorming and academic excellence. Today we're going to look at government and we're going to look at government and we're going to look at the topic titled Rule of Law. Rule of Law. So that is going to be our topic for today, the rule of law. Before we proceed, we need to look at what is the definition of the word the rule of law. Now, the rule of law can be defined. It can be defined as the predominance or absolute supremacy of the law over everybody, both the government and the ruled. Both the government and the ruled. That is the definition of the rule of law. So let us quickly consider the definition. We said it is the predominance or the absolute supremacy of the law over everybody, both the government and the ruled. Now what we're saying here is that in every society, the rule of law is supreme. The rule of law is absolute. The rule of law is above every individual in the state. And for that reason, it means that both the government, that is those in power or those that steers the affairs of the state, and the people that are located in the state are subjected to the rule of law. In other words, nobody is above the law. That's what it's saying there. Nobody is above the law. Now, the rule of law was actually, made popularized by the man called Dicey. Dicey. In the year 1885. So Dicey came out with the phrase, the rule of law. So the rule of law is actually a phrase that was used by the man called Dicey, an English professor of law. English professor of law in the year 1885 under the book titled Introduction to the Law of the States. Introduction to the Law of the Constitution. Introduction to the Law of the Constitution. So the rule of law was actually propounded by the man called Dicey, Professor Dicey, in the year 1885 in his book titled The Introduction to the Law of the Constitution. So what Dicey is saying is that those that are entrusted to steer the affairs of the state must rule according to the law. And for that reason, the law is, everybody is subjected to the law of the Constitution. That means that nobody is above the law and nobody should act arbitrarily. The government should act according to the dictates of the Constitution. The government should act within the confines of the Constitution. The government should not be arbitrary. The government should not be authoritarian. The government should not be dictatorial. The government should not be autocratic. The government should not be totalitarian. So what Dicey is saying there is that the law is above everybody. And for that reason, the government must subject itself to the law. The government should not become dictatorial. The government should rule according to the law of the Constitution. So what he's saying there is that both the government and the governed are subjected to the law under the rule of law. So the rule of law goes with what we call checks and balances and the separation of powers. So for the rule of law to be guaranteed in a society or in a state, it must go with what we call checks and balances. And the checks and balances talking about the separation of powers. Separation of powers. And what are we talking about here? We're saying that that governmental power should not be located or found only in one organ of the government. It should be shared among the three of them. That is the executive, the legislature, and the judiciary. That's what we're saying there. So the rule of law is what? Is actually the supremacy of the law. That is, the law does not, no matter how highly placed you are, no matter how your economic position or your political power or the power or the authority exercised in society, you must be subjected to the rule of law. Now let us quickly look at what we call the tenets of the rule of law. Tenets of the rule of law. Tenet of the rule of law. Or you can also say characteristics of the rule of law. Characteristics of the rule of law. We have number one, equality before the law. Equality before the law. Equality before the law. We have number two, impartiality. Number three, we have predominance of the law. Over everybody. We have number four, freedom of the press. Or the press should not be censored. Number five, punishment given to an individual must be equal to the offense committed. Number six, open trial. Number seven, the law should not be retrospective or backdated. Number eight, the law should be made known to everybody. Known to everybody. Now let us quickly explain them one after the other. We said the tenets or the characteristics of the rule of law. We said number one, equality before the law. Equality before the law. What we're saying is that everybody is equal before the law, no matter how highly placed you are, no matter your position in society, whether you are the president or the prime minister or the governor or the deputy governor or the CBN governor, whatever may be your position in society, everybody is equal before the law. Now, the law should not be bended to suit the caprices or the interests of some elite or some individuals. If such a thing happens, then we are talking about arbitrary abuse of power or arbitrary government. So what we're saying there is that under the rule of law, everybody is equal before the law, no matter how highly placed you are. That is what the rule of law is talking about. So for the tenet of democracy to be ensured, for fundamental human rights to be ensured, to ensure that inalienable rights of the citizens are guaranteed in the society, then everybody should be made to be equal before the rule of law. Nobody is above the law. That is what it's saying. So then number 2, impartiality. What we're saying under here, that under impartiality, we're saying that the right of individual should be guaranteed. The law should not be partial. The law should not be blind. What we're saying there is that in a society, for example, if an individual is arrested for an offense, he is presumed to be innocent before the law until he is proven what? Guilty by a competent court with with an impartial judge. Then we can now say that such an individual can be found guilty of the offenses he has committed. So the law should not be partial. That's what we're saying there. Then predominance of the law over everybody. So no matter who you are or whatever, the law is supreme over every individual. Then the freedom of the press. For fundamental human rights to be guaranteed and for democracy to ensure in society, governmental actions must be subjected to criticisms by the members of the press because they represent the eyes of the people. So government action must be subjected to criticisms. But when these criticisms happens or takes place, the government should not arrest such people. They should not arrest such journalists. That's what we're saying there. So the press should not be gauged. They should not be gagged. They should not be caged. The press should be in a position to subject governmental actions to public criticisms without any fear or favor. Then number 5, punishment should be given to an individual. Punishment given to an individual must be equal to the offense committed. What we're saying here is that the punishment that must be given to an individual must be equal to the offense he has committed. In other words, an individual under the law should not be given a punishment above the crime he has committed. For example, somebody that steals a Bible, then you give that person 50 years imprisonment. That is not the rule of law. That is an abuse of power. So that's what we're saying there. Then number 6, open trial, not a secret trial. Open trial, not a secret trial. Every individual that must be tried in a state must be given an open trial. It must not be a secret trial whereby the person is given a trial in a secret place and is judged and is not given the opportunity to appeal against the judgment. That's what we're saying there. So that is not the rule of law. What the rule of law is saying there is that if an individual has committed a crime, he must be given the privilege to be given an open trial where he will have a lawyer that will represent his interest in such a court. And even when the judgment is what is given, the individual must have the privilege of appealing against such a judgment. That is it. Then number 7, the law should not be retrospective or backdated. The law must not be retrospective. The law must be dynamic. It must be moving with the social, political, and economic issues that happens in society. It must not be backdated, and it must not be retrospective. That's what we're saying there. Then the law should be made known to everybody. Everybody must have access to what the law is all about. It is not something that the law is made and people are not even aware of it. And in such situation, when they contravene such a law, then punishment is given to them. That is not what we're saying. Everybody must have access to the rule of law. Everybody must have access to the law. They must be able to know what is going on in society. They must be able to know what the law is saying. Because in a society where there is no law, there is no offense. But when there is an offense, then the law must be made known to everybody in such a society. That's what we're saying. So we have given 8 characteristics here: equality before the law, impartiality, predominance of the law over everybody, freedom of the press, or the press should not be censored. Then number 5, punishment given to an individual must be equal to the offense committed. Number 6, open trial, not secret trial. Then number 7, the law should not be retrospective or backdated. Then number 8, the law should be made known to everybody. Now let us now look at the limitations to the rule of law. 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 Limitations. Now, with all the analysis we have made so far, we can now see that there are some certain limitations to the rule of law. We're quickly going to look at them now. Limitations to the rule of law. Number one is a type of government. Type of government. Number 2, state of emergency. State of emergency. Number Number 3, obnoxious laws. Obnoxious laws. Number 4, we have a diplomatic immunity. Diplomatic immunity. Number 5, we have a parliamentary immunity. Then number 6, we have a people with insanity. People with insanity. Then number 7, we have a age factor. Age factors. Number 8, we have a state security. Let us quickly look at this 8 points that we have given so far. Type of government, state of emergency, obnoxious laws, diplomatic immunity, parliamentary immunity, people with insanity, age factors, and state security. So these are the limitations to the rule of law. The first one is what we call type of a government. In a society where you have military government, or in a society where you have one-party system, you are going to discover that the rule of law may not be adhered to. Why do we say that? Everybody knows that the military are meant to defend the country against external insurrection or against external attack or to quell a riot. But in a situation whereby you have a military government in power, because they are not trained to rule, they are not public servants, or they are not public administrators, or they are not politicians, you discover that the rule of law will not be adhered to in such a political system, in such a system. Why? Because they are going to rule through the barrel of the gun. Then the society where you have a one-party system, where there is no opposition, you discover that the government will also not rule according to the rule of law. So one of the factors that can limit the rule of law here is the type of government that is being practiced or operated in society. For example, military government or one-party system. Then number 2, state of emergency. In a period of emergency, government, all in the name of what? Of ensuring the security of lives and property, may declare a state of emergency in such a society. And by declaring the state of emergency, people can be arrested arbitrarily, people can be detained arbitrarily, people can also be tried secretly in such a society. So in a state of emergency, the rule of law may not be adhered to by the government. Then number 3, obnoxious law. Government in a bid to suppress fundamental human rights, in a bid to rule with force, in a bid to rule arbitrarily, may decide to make obnoxious laws that does not make sense, or laws that are not according to the law, or laws that are contrary to the constitution. They might decide to make these laws in order to violate fundamental human rights, and also to suppress opposition in such a society. So in a period of a period where there's the making of obnoxious laws in the society, you will discover that the rule of law is going to be limited one way or the other. Then number 4, diplomatic immunity. In a situation, diplomats, ambassadors, we're talking about ambassadors here that are representing a country in another country. In a situation where these people, they violate the law or they go contrary to the law, they cannot be tried because of the immunity that they have. The only thing that they can do to them is to repatriate them back to their country. So because of that, that makes the diplomats or the ambassadors to be above the law, which is against the rule of law. Then parliamentary immunity. What we're saying there is that lawmakers, irrespective of the comment they made on the floor of the parliament, they cannot be held responsible for their statements, and that is also against the rule of law. Then another one is number 6, which is people with insanity. People that have psychological imbalance, or people that have insanity, or people that have mental degradation. You discover that such people might not be able to stand trial, irrespective of the crime they have committed. For example, if a madman kills a man, A man that was observing my mental problem kills another person. You cannot make such a madman to stand trial because he's going to be saying something else in the court of law. So people that have insanity might not be held responsible for their actions. Then 8 factors. Children that are below, below 7 years, irrespective of the crime that they have committed, they cannot be made to stand trial for the offenses that they have committed because they are still underage. Then number 8 is what we call state security. In the name of state security, the right of individuals or the inalienable right of individuals cannot be guaranteed in such a situation because of what? Because of the state security. So government, all in the name of state security, in order to secure the lives and property of people, to avoid looting, to avoid crime, to avoid all sorts of things that are negating against the rule of law. Government also, in a bid to cover up for such things, might decide to violate the rule of law, all in the name of this state security. That way, of course, we're trying to guarantee the safety of our people, but in the bid to guarantee such safety, they are one way or the other violating the safety of the people themselves. They are trying to guide one way or the other. Most especially when the state security forces or the police itself are engaged in such a thing. Then number 9, which is our bonus, is what we call police brutality. Police brutality. Of course, we are all witnessing what is going on in the world today, in America, in Africa, in all over developing countries where police brutality is a common thing, where police brutalize, where police kill, where police maim, where police also will shoot down innocent people, all in the name of of security. So we are, in a situation where there's police brutality, you discover that the rule of law will not be adhered to in such a society. Now let us quickly look at what we call factors that can guarantee the rule of law. Factors. So despite the fact that we have the demerits or limitations, there are some certain factors that can guarantee what we call the rule of law. So factors that can guarantee the rule of law. The rule of law. Number 1, we have what we call open trial. Number 2, we have what we call principle of separation of powers. Number 3, we have independence of the judiciary. Number 4, another one is what we call application of checks and balances. Checks and balances. Then we also have number 5. People should be able to appeal against judgments. Then we have number 6, freedom of the press. Number 7, we have enthronement of democracy. Then number 8, opposition should be allowed. Through constructive criticisms. Number 8. So let us look at factors that can guarantee the rule of law. Number 1, we have called open trial. We've discussed this before. We said people should be able to have open trial in a society, not secret trial. Then we also have what we call principle of separation of powers. According to Baron Montesquieu, this principle was actually propounded by the man called Baron Montesquieu. So what we're saying there is that power should not be allocated or should not be concentrated in one single individual. It should be shared among the three organs of the government, among the executive, the legislature, and the judiciary. The independence of the judiciary. The judiciary should also be independent of the executive and should also be independent of the legislature. The judiciary should be funded from an independent post, not from the executive arm of a government. The judiciary should also be able to dispense justice without any fear or favor. Then number four, number four is what we call application of checks and balances. The three organs of the government must be able to check on each other to avoid dictatorship. The executive should check on the legislature should check on the judiciary should also check on the legislature and the executive. There should be application of checks and balances. Then number five, people should be able to appeal against a judgment. Once a judgment is given in a court of law, the individual should be given the privilege of appealing against a judgment like that. So what we're saying there is that people should not be sentenced and that will be the end of it. No, they should be able to appeal against such judgment when they are not satisfied with such a judgment. So people should be given the privilege of appealing against judgment in the court of a law. Then number six, what we call freedom of the press. We've said before that the press is the voice of the people. So in such a situation, the press should be given the privilege to criticize, to subject government actions to criticism, to subject government actions to public criticisms. Through criticisms, government should be able to know their weak points and also address such issues. But in a situation whereby the press is being censored or being gauged, it will not work well in such a society. So there should be freedom of the press. Then there should be enjoyment of democracy as opposed to a one-party system or a military rule. What we're saying there is that democracy should be encouraged in the society. People should go into democratic system of a government, not a military government. In a military government, fundamental human rights is always violated. But when there is encouragement of democracy in society, you discover that fundamental human rights of people can be, guaranteed in such a particular society. Then we also have what we call opposition should be allowed through constructive criticisms. In every democratic society, opposition must be given the privilege. They must be allowed to exist. That's what we're saying there. So opposition serves as what? As an alternative party to the government in the power. So when the government in power or the incumbent government in power is not satisfying the interests of people, then there can be an alternative party that can exchange or change for such a government in such a particular society. So opposition party should subject government actions also to constructive criticisms. So in a nutshell, what we're saying here is that the factors that can guarantee the rule of law are these factors that we've listed here: open trial, principles of separation of powers, independence of the judiciary, application of checks and balances. People should be able to appeal against judgment, then freedom of the press, enjoyment of democracy, and opposition should be allowed through constructive criticisms. On this note, we're going to end our topic on the topic called the rule of law. I hope you have gained a lot today. I remain your humble host, David Oni. We want to appeal to you to always subscribe to our channels, and also to always press our notification button. So in case that we have any upcoming videos, you'll be the first person to be notified of such a video. We also encourage you to leave your comments in our videos so that we can be able to serve you better. We can be able to serve you better through this medium. So please always come online and watch our videos. We've given different lectures so far so good. They're all on the internet in the YouTube. You can go there, just click on David Oni Wiz. You will see all these videos there so that you can be able to watch them, and you can also be able to improve yourself academically. Thank you once again for watching this video. Till we see next time. Thank you and God bless. Bye bye.